Welcome to the Learning Studio, where we explore the legal forces that shape nations, societies, and global stability. In today's episode of our law series, we turn our attention to a powerful and often sensitive area of the law, one that operates in times of peace and war, military and security law. To follow more legal explorations, visit the full law series playlist linked below in the video description. Can a soldier refuse to follow orders? What happens if a government uses its military against civilians? And who decides what's legal during war, intelligence operations, or national emergencies? Military and security law answers these critical questions, balancing national defense with individual rights and security needs with international obligations. What is military and security law? Military and security law governs the conduct, rights, obligations, and oversight of a country's armed forces, intelligence agencies, and national security policies. It includes military justice systems, e.g., court-martial proceedings, rules of engagement and use of force, war powers and emergency laws, civil-military relations, surveillance, intelligence gathering, and privacy laws, legal protections for prisoners of war and civilians, Geneva Conventions, international humanitarian law, IHL, counter-terrorism legislation, and internal security acts. This field intersects constitutional law, international law, human rights, and criminal law, often in high-stakes, high-pressure contexts. Historical and legal background. Military law dates back to ancient times, with early codes like the Roman military law and articles of war in medieval Europe. Modern frameworks emerged after the World Wars when global powers realized the need for international humanitarian law, IHL, led by the Geneva Conventions, legal accountability for war crimes, e.g., Nuremberg trials, Rome Statute, oversight over intelligence agencies and counter-terrorism efforts, restrictions on the military's role in civilian governance. In most democracies, military law operates under civilian control, with clear boundaries defined by constitutions or parliamentary laws. Famous case study, Hamdan v. Rumsfeld, U.S. 6. In this U.S. Supreme Court case, a Guantanamo Bay detainee challenged the legality of military tribunals set up by the Bush administration. The court ruled that the tribunals violated both U.S. law and the Geneva Conventions, reaffirming that even during war, legal standards must be upheld. This landmark case emphasized the importance of legal checks on military and intelligence powers, especially in the context of terrorism. Why military and security law matters today. With rising global threats, terrorism, cyber warfare, drone strikes, intelligence leaks, and civil unrest, military and security law is more relevant than ever. It ensures ethical conduct during armed conflict, accountability of military and police forces, transparency in intelligence and surveillance, balance between security and human rights, legal frameworks for international peacekeeping and defense treaties. Whether it's handling a border crisis or regulating cyber defense systems, this legal field safeguards both sovereignty and civil liberties. What's next? If you're drawn to international law, public policy, or national defense, military and security law offers you the chance to work at the crossroads of law, ethics, and state power. Coming up next, we'll explore tax law, environmental law, and space law, each shaping how nations prepare for the future. You're watching The Learning Studio, and this is the Law Series, where we examine the laws that protect both freedom and order.